Hey, how are you? My name is Wayne Barrett. The reason why I made this video is because I know you're probably under a lot of stress. You're going through a very hard time. I totally understand this. And I wanted to let you know why you're getting offers for people that are just telling you that they want to buy your home and they're not trying to do anything else for you. Just being totally honest with you, foreclosure is one of the hardest things to stop. If you're in a non-judicial state such as Georgia, it's also very, very, very difficult. All right, guys. So I didn't make this video to give you no hope. I'm just letting you understand why you're getting these calls. And I get a lot of text messages when I reach out to people. They're saying, "Hey, man, f off," or vultures, all these other things. There's nothing else that a lot of people can do. I personally, I've even tested it. Um, my home is in a trust. The bank accelerated the due on sale clause, which is illegal. It's against something called the Saint Germain Act, and I sued the bank. I thought, hey, I have every right to sue the bank, and I'm not talking about this was years ago, guys. I'm talking about actively right now, still trying to get the case reopened so that I put in new evidence as of last week. So I'm talking about something fairly new. These banks hire really, really high level attorneys, and they come after you. They ignore your entries, and if you don't know what you're doing, you're not going to make it. So I just want to share with you a little bit about the experience so that you can make a good decision as to what you're going to do moving forward. Okay. So again, I personally did it. I had a feeling that I was going to win. Let's be honest, right? I was like, hey, I'm looking for justice, doing it. Everything's going to work out. So this is my story. And I'm not saying it's going to be your story. Again, I didn't mean to start off this video being negative. I didn't mean to start off this video not giving you any hope. But it really is about a 2 or 3% win rate in court, especially federal court, for foreclosures. Foreclosures are very difficult, especially in non-judicial states. So a non-judicial state like Georgia means that the bank does not have to file a actual lawsuit to take your home. All they have to do is they put it in the paper, which is another, we can go on a whole nother discussion. But when they do that, file it in the paper, they're basically saying that the home is abandoned. Then and you didn't respond, and that's what they're selling it offer. But that's a whole nother thing. So just by listing your home in a paper, they can sell your home. All right. It's not fair. It's not cool. I understand. The only way to stop a foreclosure if you are denied a modification or you don't want to file bankruptcy because it's going to hurt your credit is you're going to have to sue the bank. All right. When you do a lawsuit, you're going to have to understand exactly what you're doing. There's a ton of gurus online that's going to read you a bunch of codes. They're going to read you a bunch of laws and money's fake and all these other things are going on. And that's why I did it. I said, look, if these guys are saying that these things are real, I want to test it out for myself. When I went ahead and tested it for myself, I got a rude awakening. There is so much more to this than you know. It's not about quoting laws. You've got to have, so in the beginning, just to give you insight about the courtroom, it's not about evidence. So in the beginning on the docket, um, you know, I'll start from complete scratch. I filed mine in Superior Court. I did Superior Court. I'm here in Georgia. I did Superior Court. I'm in Cobb County. So I did mine in Superior Court because the home's is in Cobb County, right? So home's in Cobb County. Everything's recorded on the Cobb County real estate records. So I started the court case there. First thing that they did, they removed it to federal court. All right. When they do a removal from one court to the other, it's called an abatement. All right. So even though it still says that you're the plaintiff, it switches roles. All right. A lot of people do this also for like if you got a traffic ticket, you take that traffic ticket out of the state court and you move it up to Supreme Court or federal court. You turn from the defendant to actually the plaintiff. So I know I'm mixing in some things, but I want you guys just to understand where I'm coming from, right? So now it becomes an debate. So the first thing that they do is they transfer it out. They say that it's because 9 times out of 10 your lender is not in the state in which your home is. So they're saying because of that, that it comes under federal jurisdiction. They're also stating that, you know, if you're putting in any kind of federal code, so if you use a 15 USC, 12 USC, 18 USC, all right, those are federal codes. Once you use a federal code, that attorney is going to use it to take it out of state court, Supreme Court, and bring it over to federal court, even if you use the Constitution, especially. So if you say, hey, this is against my constitutional rights, I should not, you know, my home shouldn't be getting foreclosed on, even if you're saying like, look, it should be judicial, it says it, Fourth Amendment, all these other stuff, it's going to take it out of state court anyway and put it into federal jurisdiction. You have to rebut everything that is done to you. You have to read every paper that their attorney files, and you have to rebut it and answer it uh, word for word or line for line or whatever they're telling you. You know, it's their standing. You have to rebut it. You have to be rebutted. You can't skip one. This is how they get out of court very, very easy. Once they move it to another court, what they're going to do is they're going to go ahead and motion for dismissal, because you stated a claim that cannot a resolution cannot be founded on. I apologize if I said it wrong. So basically, what they're going to say is what you're stating in your complaint is nonsense. If you're going to go on the fact that, you know, it's fiat money, it's fiat currency, they're going to call you a sovereign citizen. They're going to call you all these things. But one thing that they do is they have, you know, these attorneys they have access to different things that give them cases very easy. But basically, when you're in the initial stage before the judge even hears it or sets a date, you have to prove law. The judge is only going to look at court cases. So you have to find court cases that support what you're saying. You can't just name laws or do anything like that. You actually have to find, okay, this case states that they won because of this. This state claims they won because of that. And this is why that, you know, the case should either be remanded back to the court that you initially filed it in, or why you feel that it should go to trial. All right. You cannot put emotion in it. You have to rebut it with cases. You have to have that supporting evidence. All right. Stare decisive law. That's what the judge is going to look at and make a decision that, okay, I want to move forward to either move to trial or, you know, some kind of settlement or something like that right off the top. They'll drag it out. They'll do some other things. They'll request some other stuff. You have to rebut jurisdiction, especially in a non-judicial state. Now, if you're in a judicial state, I grew up in New York. In New York, I've seen people, man, drag foreclosures out for like 10 years. I'm not even lying, like, because they're answering. All you have to do in court is answer, rebut, answer, rebut, answer, rebut. They cannot just take your home. In Georgia, once they kick it out, they're just going to go again, you know, and a lot of people do this as well in bankruptcy court. A lot of people think that bankruptcy court is this big fix. It's not. So when you go into bankruptcy court, excuse me, they're going to do the same thing to you. All right. You're going to file your bankruptcy. You're going to tell the judge you want to do a 13, a 7, whatever you want to do. They're going to file to have it removed out of bankruptcy and put back in. All right. You have to show the ability to pay. A lot of times when people go into bankruptcy court, they don't understand that your payments are going to go up. So if your payments were $1,200, okay, and like right now, today's June of 2023. I don't know the exact date. It's kind of late. I just wanted to make this video for you guys. I believe it's the 24th today. Interest rates are like 6.5% or 7%. All right. So let's say you go to do a modification, you're running into problems. You had a 3.5%, which is what I had, right? Or what I have, 3.5%. Now they're going to say they're going to modify your loan and make everything better. Well, what they're not going to tell you is that they're going to modify your loan and they're going to have to give you today's rates. All right. So imagine you had a 3.5%. Now you're going to do a modification to a 6.5% or 7%. That's going to raise your payment. If you had difficulty paying it before, what do you think is going to happen to you today? All right. Along with that, they're going to give you the payment plus whatever you're behind. So let's just say you're behind 12 grand, you're going to have to pay back that $12,000 plus your normal payment over it could be anywhere from a 12-month to a 36-month period. Okay, so that means now your payment's gone up. You've got an additional load on you. All right, and they're eating away at your equity because they're tacking on those extra fees. And let's not forget the attorney's tacking on his fees as well. So let's just say before you went into foreclosure, you had $50,000 worth of equity. All right. Every month you're going to see, I don't know, depending on your payment, depending on the bank, depending on the attorney, anywhere from 2 to 3 to maybe even $4,000 in fees per month. So let's just say you got 6 months, you're going to rack up a $30,000 bill that's eaten into your equity, eaten into everything. And that's why when people call you on the phone and they say, hey, we want to make a cash offer, and you're like, yeah, I want full price. Because let's get real. Once this starts to sink in and you're at home, you're doing the math, you're like, wow, my equity is being eaten up. I can't sell, I can't do anything. Right. So the first thing that we want to do is we want to make sure that you're getting the highest price, because that's what was in my head. I was like, hey, if these guys want to take my home, there's no way. I've had my house for 15 years. I want to get this done. There's no way I'm taking a loss, and there's no way I'm selling my home to someone and they're going to profit while I lose out. I got to start over from scratch. I get it. I totally understand. And again, I went after these guys because I wanted to see exactly what was happening. um Another thing I want you to know is that they don't play fair. So attorneys, even if you get an attorney, there's something that you have to know. It's called corpus juris secundum 7. I think it's like chapter 7, verse 4. All right, but you can just Google corpus juris secundum 7:4. All right, and it'll come up, and it will tell you that all attorneys, not some, all attorneys have a dual responsibility. All right, and it is to the court and to you, but the first responsibility is to the court. So what that means is if they're winning and they're really doing well in the case, and the judge is like, look, you know, we can't let you win this. They they're not gonna your best interest. I mean, look, there's some good attorneys. I don't want to make any enemies with the bar or anybody like that, because these boys will come for you. But the thing is, there's some good attorneys that don't really understand what they signed up for when they joined the bar. I've noticed that. So don't call every attorney out. There, make friends, really give them a chance. But there's a lot of them that don't understand what they signed up for, and when they are approached to have to do something that is unethical to them, that's when they understand what that oath that they took to the bar means. Okay. But basically, what I'm telling you guys is that bar association, um, you know, it's the court. So the United States is a corporation. This stuff you got to look up on your own. I'm just letting you know my opinion, right? I'm not an attorney. I'm not trying to give you legal advice, right? We got to do the disclaimer. None of that. This is just information. But when you're in court, you have to understand that that same federal court, that state court, all those courts, they're a corporation of the United States. Okay. When you start an LLC, an incorporation, all of that, that's a part of the United States. So there's no way that the United States federal court, that everyone's like, oh, I'm going to federal court. Federal court is a corporation of the United States. They're friends with all corporations, especially major corporations. So i.e. banks, i.e. Companies like Walmart. They're not the federal government is there to protect these guys. They're not there to take them down. So that's a misconception that a lot of us have, like, oh, I'm going into federal court, my constitutional rights and all these other things. There's a lot of things that when you get into court, you're going to learn. A lot of these things that these gurus are talking about, they don't work. They simply don't work. And I'm telling you, I'm not someone that is just talking out of his ass. I'm in court right now. I'm fighting them. Okay. And they do dirty things, they like, they try to coerce you. They try to list your home. The attorneys, they're all friends. And if you call them out, if you do anything that makes them feel uncomfortable, or if you know too much, then they get very together, and they'll come for you. All right. So I just wanted to let you know that's why you're getting these calls. It's hard for people to help because I'm telling you, it's less than a 3% win rate in court, especially in a non-judicial state. Foreclosures are, it seems to be something that was set up for a lot of people to lose at some point once they start to squeeze the middle class and all these other classes, guys. So I just hope that you have a better understanding. This video, again, is not to make you feel like you don't have a chance. There is chance, there is hope, you know, keep a positive mindset. But I think the biggest thing to do is to have a plan. All right. It's a scary time. All right. Getting these calls and these text messages from people, you know, and I'm guilty of it too, but you know, I just know that there's nothing that you can necessarily do unless you either have the money, your circumstances change, and you can afford those payments. Then, by gosh, go back in, pay them, do whatever you got. But you got to know law. This is not just I'm going to listen to social media, or I'm just going to get emotional and tell them I owned a home and how can they do that? I remodeled, I did this, and you're trying to take my home. They don't care about any of that. Okay. If you don't know law, if you cannot find cases where people have won, if you don't know how to, the federal rules of civil procedure work, all these things are very, 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 very important. And you do not want to go into court with an attorney. Unfortunately, you're never going to win. I've never heard of anyone winning with an attorney. And if I'm wrong, someone please update me, put a note under here or get in contact with me and let me know. But, the truth of the matter is that if you go into court for foreclosure, it's just something you don't want to do. And if you go in with an attorney, they're going to make you a ward of the court. You already lost. You've already, they're going to give the court jurisdiction. They're going to give them all these things. So what I want you to know is that, very important too, real quick. If you do go in there, it's not pro se. All right. It's not pro se. All right. It's in propria persona sui juris. You got to look at these things up yourself. I'm not an attorney. But pro se, whole nother jurisdiction, all those stuff. It doesn't matter. You got to put in your affidavits. You got to really know procedure, guys, because that's what they're big on. You come in and you don't know procedure. These attorneys don't care about common law, all that other stuff. If the paperwork doesn't look like what they're accustomed to seeing, they're just going to throw it out. All right. But big thing that I do want to leave you off, just a recommendation. Again, I'm not an attorney. I'm not trying to get your business. I'm not soliciting you as an attorney. But a big thing that they are going to get you, that you must say, is that there is no landlord tenant relationship. When you say that, they can't just go to a manual and just read it out of a book, because a lot of these judges in the lower courts and sometimes in the higher courts aren't necessarily judges. But that's a whole nother discussion again. Guys, there's so much to this thing that when you get in there, you realize like this whole thing is just a trap, man. A judge is not supposed to sit the bar association and be a federal judge. That happens a lot. You're gonna see so many different things. But before I get off of here, I'm just gonna prove to you that I'm currently in court. This is my case. My name is Wayne. I'm local. I'm here in Georgia. And if this post can help anyone make a rational decision, that's why I made this post, right? I'm just in a regular t-shirt. This is how I dress. I'm not trying to put on a show for anyone, but I felt like I had to make this video and let you guys see. So real quick, I'm just going to share my screen, show you my docket, let you guys know that I'm actually in court, and it's not easy. I'm telling you, it's not easy. I was so high. I was like, man, I've got these guys. I got these guys. Now I'm over there on Rule 60B, like, hey man, open back up the case, open back up the case. So give me a second. Let me share my screen with you guys. It's taking a little while. Give me a second. All right, share screen. Desktop. All right, perfect. All right, so this is the docket. All right. Basically, I just wanted to show you guys this right here. This is kind of how they got it thrown out, right? The matters before the court magistrate judge, final report recommendations. with regard to plaintiff's motion to remand. So what I did, I tried to remand it, meaning return it back to superior court from federal court. Denied defendant's motion to dismiss, right? So they're the defendants. I'm not the defendant. I'm the plaintiff. So they're the defendants. So I've sued the bank, the attorney, the MERS, because MERS was online, and HUD. I have a FHA loan. So you'll see a lot of this stuff, guys. So, the first thing they also try to do is separate the foreclosure attorney, saying that the foreclosure attorney is acting in the capacity of counsel, but yet when they send you the foreclosure information, they say that they are a third-party debt collector. And when you look at the listing in the newspaper, if you read it all the way at the bottom, it says that they're acting as trustee or attorney in fact for you and I, not for the bank. They're using the paperwork that we signed at the closing table where we waived our rights. And that's the first thing that their attorney entered in, is the document that I signed that said waiver of borrower's rights. And when I read it, now that I understand trust law, it's a trust. It's all around trust. We waived our rights. We give them the right. All right. They can act as our attorney. They can do everything. So they're basically following they're doing the foreclosure as if it's on our behalf. All right. So the right defendant's motion to dismiss be granted. All right. There it is. All right. Plaintiff's complaint be dismissed. Again, I'm the plaintiff, be dismissed, and defendant's motion to strike docket denied as moot. She wanted me, the attorney right here. I had filed some items on the real estate record in the real estate recording department, and she wanted the judge to order that those be taken off, but the judge said, okay, well, we're already throwing out the case, so it's irrelevant, so, it just says here, plaintiff has filed objections to R&R, right? Meaning that I was challenging this final order for the following reasons. The court adopts final recommendations, magistrate, judge opinion, and order of the court. All right. So give me a second. I'm just going to stop sharing. I'm just going to show you the dates on this so that you guys know it's low. It is very recent. All right. One sec. Let me just update this screen. And so what I'm going to be doing, I'm just going to be sharing with you guys my experience going through this. It's a crazy experience. All right, so I'm going to show you right here. So you guys know, I said, what, today's the 24th, right? Yeah, I think today's 24th. So here it goes. Let me share my screen one more time with you guys. Boom. All right, so as you can see, 622, all right, motion for relief from final judgment. All right, that's me. All right, so you guys can see it, 622, 533, right? They denied, they do. I mean, guys, I've been fighting with this thing, fighting. So I'm not a person that just come in and telling you guys something that I don't know. I literally am in court, in federal court. Okay, I'm in federal court. I'm absolutely doing this. I'm not a guy that's just speaking out of his ASS, like I said earlier. All right, I've learned a lot. They're using a top-notch attorney that is licensed in Alabama, here in Georgia, and some other places. And when I tell you that a lot of this stuff that people talk about, suing your car for your car, suing for your suing the credit reporting agencies, just suing for everything, credit card debt, all this stuff. Listen to me. You going in there and knowing 18 USC, 15 USC isn't going to do it. Just being point blank. You need to know case law. You need to know trickery in the court. You need to understand that when you hire an attorney, you may not win. All right. If it's something small, hey, they're reporting something crazy, blah, blah, blah. But foreclosure, best. Sometimes what you can do, and if it's a last minute option for me, because I'm going to go through the whole process, I'm going to just share it. is going to bankruptcy court. I'm doing research now that you can actually file a case inside of bankruptcy court. So you're not just there just to do bankruptcy. You can actually file a active case, like, or like whatever was denied on my side here, I can go into bankruptcy court and say, hey, judge, because bankruptcy court say, hey, look, I need to enforce this. This is, and these are the reasons why. Can you take a look at that? All right. So I'm sorry that it's so long-winded, guys, but I wanted to make this video, show you guys exactly what goes on, why people are just like, hey man, I'll buy your house and I'll give you time to move out. There's not a lot of people that can win in court. Best that they can do, especially when interest rates are high, is they're going to give you a higher payment. They're going to eat away at your equity. And also right now, with interest rates being so high, it's not favorable for a lot of investors to borrow money against. So creative financing. So you're going to get a lot of offers for creative financing, right? Yeah, a lot of people are going to be like, oh, I just want to be done with it. I don't understand this. I don't want to carry any note. You got to be a little bit more open-minded if you're looking for resolution. I can make a whole nother video on that, but the easiest way to explain that to you is that people are going to give you cash in your pocket. You're going to carry the note, but they're going to pay the mortgage. They're also going to have, you want to make sure that they have a a statement in the contract that if they do not pay, you take back the home. So it actually could be a win-win for you if they default. All right. But anyway, that's my video. Know what you're doing if you want to fight for your house in federal court. Keep, have all your records put together, understand the civil rules of, federal rules of procedure. If you're in federal court, you got to know the civil rules for state court. You got to know these rules. You got to know how to file petitions, motions, abatements. There's so much to learn, man. So guys, I hope this helps, and let's get it.